today I'm meeting with mediator Dan Day. Now there's more to Dan than just being a mediator, but we're going to speak today about what he does in his capacity as a divorce and domestic relations mediator. And before we go any farther, let's get your contact information for the purpose of people that would want to call you. So let's get your name and your address, telephone, and website or email if you want to have people contact you in that way.
Okay. My name's Daniel L. Day, and my address is 9571 South, 7th East, Suite 104 in Sandy, Utah. And my phone number is 801-676-1506. And I do have a website. It's www.d-daylaw.com.
Okay. So you're an attorney as well as a mediator.
I am.
All right. And so it's kind of interesting because you have done domestic relations work and still do from time to time.
Yes.
But it's not your primary focus when it comes to your law practice. Would that be correct?
That's correct. Most of my work is commercial litigation.
So it's nice to know that you've got experience as a lawyer, but also that it's not your primary practice area as a lawyer, because I think that brings a unique perspective to mediation. You can it's almost cross-training, if you would, because you know how other kinds of situations are litigated or dealt with, as well as divorce and domestic relations. And I think that's one of the things I like about you as a mediator, is that you tend to bring a fresh perspective where you really get the best of both worlds. What do you think about that? I mean, am I off? I mean, I realize that's kind of a puffball question, but I think it's a good place to start.
Yeah, well, I do feel like as a mediator, knowing not just domestic law, but real property law and other things that dovetail well with domestic relations, that it does help me be a little more informative in the process when I'm mediating a domestic relations case.
And I think for you or anybody else in a similar situation, it also means that you're not locked into one way of thinking, and that conventional wisdom isn't something that you just march in lockstep with. You're saying, hey, there's other ways of looking at this, or I can, by analogy, we can do some creative things.
Yeah, maybe. I haven't thought of it that way, but
yeah,
that's possible, yeah.
Now, the purpose of our meeting is not just to talk about you specifically, but also to introduce people to mediation and that process in a divorce or a child custody or other kind of domestic relations situation. So, although you and I may be familiar with it, could you just take us through the process a little bit? So once a case is filed, if you weren't aware of this, folks, these divorce or paternity or other kinds of cases are required by law to go to mediation before you can go to trial. Now, I know that hardly anyone is looking forward to going to trial if they could settle, and so this is usually something that most people are on board with anyway. But some people aren't aware of the fact that it's mandatory under law. So, take us through this situation where somebody has filed a divorce case, and they then say to themselves, all right, at whatever point we feel it's a good time to mediate, we need to go to mediation. What happens next?
Well, let me back up just a little bit and
Sure.
say mediation is, quote, a voluntary process. But the rules in Utah now require cases to be mediated before the court will give you a trial date. But nevertheless, mediation is still a voluntary process.
And what do you mean by that? Since you're required to do it, explain to people what makes it voluntary, or what aspect of voluntariness are you talking about?
What voluntary means is that your decision to settle or not is entirely voluntary. If you just show up to the mediation in good faith and are unable to settle, that's perfectly fine under the rules in Utah.
And this raises a good question. So, I go to mediation, and I try really hard. And whether my spouse or not tries really hard, I walk out of there. But isn't the court going to be angry with me when it finds out that I didn't settle in mediation?
No, the court should not know anything about what happened in the mediation, but the court receives what's known as a ADR disposition notice, which just says that it either settled, didn't settle, or didn't mediate. And
So does the court know about what we talked about and how I made all these offers and she never accepted any of them?
no, in fact, the court is bound not to entertain any of that information as evidence. And if the opposing party attempts to introduce it as evidence, it will be stricken, or at least if the attorney representing that party objects, it won't be introduced at all.
Why is that? I mean, why wouldn't the court want to know about how hard people or how little people worked at settlement and mediation? Why shouldn't that come up?
Well, the point of mediation is to provide an environment where it's safe for the people to talk openly. And in order to respect that vessel, if you will, where they can sit down and speak candidly, the laws in Utah have established a complete confidential rule barring disclosure of that information to the court.
Yeah, the idea being that if I knew that something I might make an admission, or I might make an acknowledgement of something in the course of explaining my offer to you, that if it came out in court, it's like, look, I would never want that to be discussed in court, but I will discuss it with you in the course of trying to settle. I would be afraid to do that. I might say, you know what, I'm not going to say anything to Dan. You know, I'm working out some deal with you, but I'm not going to say anything because I know that you're going to run to the court and blab about it. So in order to make people feel free to discuss things openly, candidly, completely, everything that happens in mediation is confidential and can't be brought up.
Yes, to a point. That doesn't mean that you can come into a mediation and just say all of the truth of your case and then later go back to court and say, oh, no, you can't talk about that because we talked about it in mediation. Anything that's otherwise discoverable and a true fact, whether you discuss it in mediation or not, if it's a fact, it's admissible into evidence.
That's a good explanation, because a lot of people are totally confused by that, and with good reason.
Right.
All right, so we know that it's a place where I can be open and candid. I can't just bury the truth in mediation, but I don't have to worry about what I talk about coming back to bite me if I don't settle in mediation. You've explained that it's voluntary in that the court doesn't demand that I settle.
Exactly.
I can if I want. Now let's start the mediation process. We've made an appointment. How do we actually, we're making an appointment. How do we do that? I mean, does the court mediator, is that person employed by the courts? Is that somebody we have to meet with in the courthouse?
No, mediators are not employed by the court. The court does have a court-approved roster that has a list of mediators that have had specific training for, there's basic mediation training, which allows you to do commercial matters, and then domestic training, which is an additional amount of training to ensure that the mediator knows the complexities of domestic mediation. But you don't contact the mediator through the court.
Okay.
You can find a list of them on the court's website, but you can just find a mediator and call them. If you're not represented by counsel, and call them yourself, and the mediator will oftentimes contact the other party and set up a time when you can mediate.
So you hire a mediator much like you hire your own lawyer. It's your choice.
Yes. Well, it requires the agreement of the other party.
But as long as both of them agree to use Dan Day, for example, then you'll be the mediator.
Yes.
All right. So these parties, whether they're represented by lawyers or not, and we'll touch on that a little later, they've both decided that they're going to use a mediator, and let's just assume for this situation it's you.
Yes.
They then schedule a time to get together. Is that at the courthouse?
Typically, no. The court does have some facilities limited for special cases, but most of the time they will meet in my office, or I will travel to one of their attorney's offices to conduct the mediation.
Again, simple, but for a lot of people that aren't familiar with this process, it's good to know. So we've made the appointment, and we decided to come meet in your office. And what do? Do we do you sit at like a bench, like a judge, and we sit on the, facing you? Do we stand? Do we? What do we do? How do we have? What does this mediation look like when we get there?
Yeah, I think every mediator is a little bit different, but in my office, I have a conference room where we sit down at a conference table, and I'll sit at the head of the table, and I typically have the parties sitting closest to me, and if they have counsel, their counsel sitting beyond them. But no, it's not like a courtroom setting at all. It's much more informal.
Along those lines, I mean, do you have the power to impose any conditions on people or make them do things or report to the court about things you'd recommend be done?
No, if you're suggesting that a mediator might decide the case in any way,
Yes.
No. Anything that I do is just to facilitate the parties reaching their own agreement. I, though, personally do have some ground rules. I insist that the parties are civil with each other and with me, and that they respect my presence as the mediator in conducting it in a professional manner.
And although that may sound obvious to some, why is that?
Well, part of the reason that mediation is effective is that people can come to a safe environment. Not just safe knowing that what they say is going to be kept private, but that physically they're not going to be assaulted or harmed in any way. And so,
Or insulted the entire time?
correct.
Just called names. Okay, so we are there, and how long do mediations get scheduled for?
I typically open the whole day for mediation. Some parties can't, physically and emotionally stand the whole day, but typically an entire day is enough to get the dispute resolved.
At least you'd hope, wouldn't I mean,
Yeah.
like, so what, break for lunch?
Yes.
But then the rest of the time you're there. So kind of a 9 to 5, 10 to 5 kind of a thing?
Yes.
Okay. What kind of paperwork do you have to provide the mediator in advance? When you're going to court, you file a motion or a memorandum or a brief and things like that. So what does Utah law or you require be provided in advance?
Utah law doesn't require anything in advance. I don't require anything in advance, but I do appreciate it when the parties furnish me with what I call an intake questionnaire. Especially in domestic cases, it's important because sometimes there are circumstances where a protective order is in place, or one of the parties feels like they might be physically threatened by being in the presence of the other party. And under those circumstances, I would make special arrangements beforehand.
Okay.
But in addition to that, it's nice to have a mediation brief, we call it. That's just a fancy name for a letter explaining, what your positions are with regard to the issues in your case.
And why is that helpful?
Well, that saves the parties time and money, because if I can quickly review some introduction material and know a little bit about the case, we don't have to spend time talking about it.
Right. You don't have to spend hours just getting up to speed on what the problem is. You can jump right into saying, I know what the issues are, I know what the disputes are, now we can address those without figuring out what they are.
Right, and I'll say that when you take the time to write those down and solidify your thinking about it, you can put it in a much more concise form. If you come to the
That's a good
mediation,
point, yeah.
if you come to the mediation having not done that, you will spend time and money, mediators' fees, talking about your case. And although I do think it's an important part of mediation that the parties get some things off their chest, oftentimes that becomes a very long process where the parties need to get a lot more off their chest than they could have if they would have solidified that in writing.
That's an excellent
quickly.
point. Because that day flies by fairly quickly. It may
It does.
sound like a long time, but you still want to be efficient.
Yes.
All right. Is mediation a service of the court, or do you have to pay for it?
No, it's not a service of the court. Typically, you have to pay the mediator's fees. For
Well,
people that...
and this is something, this is kind of an in-joke among lawyers, but, well, do you do any free mediations for people?
I do.
Do you like doing free mediations for people?
Well, when they've been pre-screened by the court pro bono coordinator, and they come with an expectation that I'm only giving 4 hours of service for free, and that if they go over, they'll be paying my normal rate. Yes, it's a good service. I enjoy doing it for people that can't afford it. I will say,
So that's
however,
important. In other words, it's not just everybody. It's not a lottery. You have to meet requirements of not being able to afford it. You know
that's
what I mean?
correct, and the court does that screening for us.
Okay.
I will say, however, though, that my experience with parties that are not paying for the mediator often waste their time in the mediation and are more unreasonable than those who are really paying. And
So having some skin in the game really does focus your thinking.
it really does. Yeah.
Okay. You've done an excellent job of explaining some of the simple things that people just don't know about the process. Tell me a little bit about your personal approach or your philosophy about how you like to handle, and let me just give this to you so that you know what the parameters are. A divorce action where you've got a husband and wife and some minor children, 3 or 4 minor children. They have a house, they have some debt, there's some retirement, there's a question of alimony, child custody support. What does a mediator do to cause this case to settle, or help this case to settle is a better way of looking at it, as opposed to just letting the judge determine it? I mean, what's so bad about going to court, me making my arguments, my wife making her arguments, and then entrusting the judge with that decision?
That's a long question, but
It is.
I'll start with the end of the question there. There's nothing wrong with going to the court and having the judge make a decision. We have a fine judicial system, and when all else fails, it works. And you'll get a decision from the judge, and it'll be final, except for your option to appeal the decision. But the advantage to mediation is that it's much more flexible than the courtroom. There's only so much a judge legally can do, and there's only so much a judge practically can do. By and large, he'll do what the statutory requirements spell out for him to do. He has discretion to do lots of things, but judges are very busy people, and they will not appreciate the fine nuances of every divorcing couple's schedules, their special needs of their children, and all of those things that are intimately familiar to the parties themselves.
Right. And I'd point out that you hinted at this, and maybe you were going to get to it, is that the parties, when they sit down in mediation, are free to agree on almost any outcome, any arrangement. If they can agree to it, almost always the court will put its stamp of approval on it. A judge, unfortunately, oh, my phone rang. Let me just check that real quick. A judge, unfortunately, is limited by the law as to what he or she can and cannot do. The judge may be given 2 choices. I can do this or that, or 4 choices. I can do one of these 4 things. But the parties may have far more options because they've agreed. Where the judge, if he or she has to make a decision, is saying, the law says I can make this decision, but that I'm limited to these 4 choices. And the judge may even say sometimes, I don't like any of my options, so this is the one I like, this is the one I hate the least.
Yeah.
Okay? So, with that,
with both the parties at the table, typically what I like to do is to keep the parties at the table as long as possible. There are many mediators with a different approach. They give a introduction of themselves and the mediation process to begin with, and then immediately they caucus into separate rooms and basically shuttle offers back and forth.
So let me make sure I understand this. You're saying that they may meet together at first, the mediator and the parties and their lawyers if they have them. They all meet in the same room and they're kind of welcomed and given an introduction to the process.
Correct.
But then after that, they may actually split up such that party A is over here, party B is in a different room?
Yes.
I mean, with a door and everything?
Yes.
And then the mediator goes back and forth.
Correct.
Okay, what's the purpose in doing that?
Well, there is a important purpose served by that. Sometimes the parties can't communicate with themselves. Sometimes it becomes too contentious and we do have to separate them up. Other times the party's not comfortable saying things in front of the opposing party that they do feel comfortable sharing with the mediator, who then can discuss that in confidence during what we call a caucus and arrive at an offer that they could make based on that interest that's really important to that person, but they're not comfortable sharing with the other person.
So it actually, because that sounds to me like that's a lot of time. It's kind of like back in school, it's like, well, tell Dan that I don't want to play with him today. And it's like, well, tell Eric that I wouldn't want to come over to his house even if I was invited. The back and forth thing.
Yes.
That could be a problem, but what you're saying is sometimes, though, that if they were all in the same room, somebody might be too afraid
Correct.
to talk. Somebody might be unwilling to discuss offers or formulate deals without bouncing it off the mediator first or making sure the mediator understands it.
Correct.
Another thing that I'll just ask, what about, give me an example where a caucus allows me to talk to you so that I know that whatever should be communicated is communicated. Like, for example, let me just kind of clue you in as what I mean. Is like I might say, well, there's a range I'm willing to offer. There's 2 or 3 things I'm willing to do. Depending upon what they say, here's what I'm authorizing you to do. Could you give us an example of how that can work in a caucus situation?
Yeah, well, typically everybody wants to keep their bottom line confidential. And so when we split into a caucus, mediators do this differently, but my practice is to inform the parties that if there's anything discussed in the caucus that they want kept confidential, they have to tell me before I go to the other side. Otherwise, I'll assume that what we've discussed in the caucus is free to discuss with the other side. But we discuss that before I go to the other side, and those things that, obviously they'd want to keep their bottom line confidential, and they're hoping not to have to go that far.
Could I do something like this then? I could say, all right, you're meeting with me privately, and I know that my wife's in the other room, and there's a question of how much alimony I should pay. And I know I'm going to have to pay some in this particular instance, but we're very far apart. So I might say something like this, saying, well, I can tell you my bottom line. I want it to be $1,000. I don't think I could get away with any less than that in good conscience. But she wants $10,000. I'm exaggerating to make a point. All right, Dan, tell her that I'm willing to go to $3,500. But I want you to go in and tell her my offer is $2,500. But if she says that's no good, then you're welcome to tell her that it'll be a $3,500. But if I do $3,500, I expect that I will be able to choose when I take the kids for the summer at my discretion every year. And you see how that works? In other words, I can lay out a plan, and I can tell you if then, so that it's not, you actually don't go back and forth, back and forth, back and forth, but I may actually use you to my advantage. Not that I'm taking advantage, but I can say offer 25. If she takes it, just we're done, and we'll talk about the next subject. But if she doesn't, and she demands more, kick it up to 225, 3,000, 35, whatever I happen to say, and then add this thing as well. I can do that.
Right. Well, and it gives the parties an opportunity to discuss the reasonableness of their offers with the mediator in confidence. And there are differing philosophies about mediation, and as a mediator, we have to be careful not to give legal advice or to advocate for any of the parties. But my practice, if you will, in mediation is that we have to at least be informative to some extent without giving legal advice. They have to, a lot of parties, even parties that are represented by counsel, sometimes don't have a good understanding of what the range of possibilities are, what the limitations are. I'll give you an example of that. Oftentimes when I'm mediating, people will think that they can negotiate child support, and they don't understand that it's a statutory formula, and you have to plug in the numbers, and the court is not in a position to change that. And even if you agree to a different amount, I know there are fine nuances.
There's some exceptions, but essentially you've got to convince the court to depart from those guidelines.
Right.
So even if your ex is willing to accept nothing in the amount of child support, that doesn't necessarily mean the court's going to approve that.
Correct. And so in a caucus, we could have a discussion about those things and help the parties understand the reasonableness of some of their positions.
And before we met, as we were setting up, you mentioned another good example where it's not so much that you are judging the positions of somebody, but let's face it, we all live in this world, and we have many shared experiences. And if somebody says something about, well, I think I should get all the equity in the house, even though we bought the house together, a mediator might say, well, tell me why you think that makes sense. That's not saying that it doesn't. It would just be something like, well, that's interesting, because most people would presume that it should just be a 50-50 division, but perhaps you could explain to me why you are the exception. There may be an exception.
Right.
But if there isn't, again, you said the mediator can help people to kind of evaluate. It's like, yeah, why do I feel like I should get all the equity in the house? Well, I just want it, but I never thought I'd have to explain it. Now that you hold my feet to the fire, it's like, yeah, gee, I can't think of any reason why I should have any more of the equity than she should.
Right. And we as a mediator, at least in my practice, would be to explain that generally the law says that the court divides up assets equitably, which for a busy judge means more or less half and half.
In fact, the presumption is, when it comes to assets, the presumption is an equitable division is an equal division unless you can show why you're an exception to the rule. And those exist, but here's an interesting part about mediation. Somebody might say, well, I know I'm entitled to 50%, but I'm willing to take less in exchange for something else.
Exactly.
That a court may or may not even notice or care about or even want to do. Just saying, you know what?
Wouldn't have the time to.
50-50, 50-50, 50-50, and both people, somebody could go away with 50% and be unhappy, saying, I was willing to give more if I would have gotten something else that I know my ex would have taken.
Right.
Interesting. All right, so who pays for the mediator?
The parties pay for the mediator.
Okay, and, well, they pay, I mean, do they pay the same amount, or does the loser pay? Who pays for, I mean, is it the beginning of the mediation? Is it the end of the mediation? I mean,
well, mediators have different billing practices, but my practice is the parties pay 50-50. And
do they have to do that?
No, that's something that is subject to mediation. They may. Okay. I've been in mediations where, at the end of the mediation, the last straw was the mediator's fees, and they agreed to settle with one party paying the entire mediation fee. I will say, however, though, that I have never, I'm not to say that I wouldn't, but I've never started from the starting point that there's an unequal balance in the payment of the fees.
Even if one of the parties makes all the money or something like that, and one of them's a stay-at-home mother, for example.
Yeah, like I said, there may be circumstances when I would do that, but it would have to be disclosed. For example, I would never say, husband, you make more money, you're going to pay 75% of the bill, and wife, you don't make as much money, so you're going to pay 25% of the bill, and not disclose to the parties what I'm doing.
Right.
They would have to agree to that all up front.
So the presumption is, in your case, and probably with most mediators, because you've been to mediation as a lawyer as well.
Oh, yes.
The presumption in most cases is it's 50-50. They split the bill 50-50, irrespective of how much money each person makes.
Yes, and that's just to accentuate, if you will, the neutrality of the mediator.
Mm-hmm.
If, as a mediator, I never want to be second-guessed afterwards, having somebody say, well, you steered this ship in the husband's direction because he was paying more of the bill.
Mm-hmm.
And so that's something I'd be very cautious about. But there are circumstances, and I've been an attorney representing a party when there was a vast imbalance in the income of the parties, and I did negotiate with the mediator for an imbalance in the fee, but I did that
At the end.
No, I did that at the beginning with both parties knowing and agreeing.
I see.
And the mediator consented to that.
Okay, if somebody goes to mediation without a lawyer and the other party has a lawyer, what can the mediator do to make sure that that unrepresented party is protected? Now, by the way, that's a trick question. It's a setup, but it's a question I know a lot of people will ask. Hey, I'm going without a lawyer, so that mediator kind of has a duty to me to look out for me. Is that your philosophy?
No. The mediator isn't looking out for anybody, because that would cross the line of neutrality and come to the point of advocacy.
But Dan, I mean, I'm poor and I've had bad experiences with lawyers, but you're a lawyer. You can answer my legal questions, can't you?
Well, I can give information about the law, but I can't do the legal analysis for the unrepresented person.
Well, you can just give me what you would do if you were in my shoes, right?
You know, when I'm mediating with parties that are not represented, whether one side's represented and the other side isn't, I don't do that, because then the parties may assume that I have crossed that line and am advocating on their behalf.
Or sympathizing, yeah, and just saying, it's like, I really prefer you over the other one, over the other party, or something
Right.
like that.
And so I do avoid that, but when counsel are present, I am much more willing to say, you ought to do this,
And why is that?
because they have their attorney there.
Yeah, they've got a lawyer there to argue with you or to explain to their client. And I will tell you, if I can weigh in there, is that I think that sometimes people think going to mediation without lawyers is saving them money. Well, if you've got a lawyer from the beginning of the case, I think you're doing yourselves a disservice in most instances without going with your lawyer. If you make a bad deal that you didn't know about, the mediator's not going to tell you made a good deal. Or a bad deal.
Yeah, that's not a
So your lawyer can be there to help you, because if you sign an agreement at the end of that mediation without a lawyer, there's a good chance you're going to be stuck with that. Very rarely can you set aside that kind of... The other thing, though, is that the mediator is far more freed up to give opinions and kind of act as a reality check and ask questions like, really? 75% of the equity in the house? Why is that? I'm having a hard time as the mediator understanding that. I'm not saying I like it or don't like it, but it's not apparent to me why you're proposing that. Whereas you'd have a much more difficult time if even being able to do that when people aren't represented. Yeah.
Yeah. The nice thing about mediation with attorneys is that we can have those candid discussions about the law without the mediator crossing the line into advocating.
Yeah, because both parties are protected. They have their own legal counsel who can say, hey, the mediator's full of it. And the mediator can even say, well, that's fine, because you're welcome to your opinions, but I'm just giving you mine. And everybody does benefit. I mean, the lawyers can benefit from that because they might say, that's interesting. I hadn't thought of it that way. Or, oh, you've done this before, or you've mediated a case like this that had this happen before. It really does free up more ideas to be generated, more options.
Yeah. I will say that, in all candidness, not trying to promote lawyers in the process at all, but lawyers serve an invaluable service in a mediation.
And this is, because you're saying you've been in situations where people show up without lawyers and when they do.
Right. And oftentimes, those that are not represented by counsel, not having any perspective in the law, they do come with unreasonable expectations, and it makes it much more difficult to resolve cases without qualified attorneys.
And I've noticed something is that they may not realize that they haven't discussed all the issues that need to be addressed. They may have gotten caught up on 3 things, and then they reach agreement on 3 things and think they're done, but there were 2 more.
Right.
And they didn't talk about it, and the poor mediator didn't know. They said, we're done, we're happy. And then they find out, the judge or the court might say to them, it's like, well, I'm glad you settled those 3 things, but this case isn't over. What do you want to do with the other 2? Then they have to go back to mediation again, or maybe they go to trial. So again, lawyers help to ensure that all those issues get addressed. And again, it sounds like it's turned into a lawyer infomercial, but it's not. It's meant to say you don't have to go, but you do make a choice, and there are some things that will happen when you go unrepresented because, and I want to make sure this is a clear point, I'm sure you do as well, the mediator is not there to be a proxy for lawyers.
Absolutely not. Yeah, and that is a problem. I often, when parties are unrepresented, they often want to say, tell me what I should do.
You're a lawyer. You know what you know the answers.
Exactly.
You can give me some advice, but it's like I could, but then I wouldn't be serving as a mediator properly.
Right.
Another question I wanted to make sure I touch on before we end, because we're just getting to the end. Can you testify? Can you be called as a witness?
No, I cannot be called as a witness. And, well, I might be called as a witness, but I will, under the law, be barred from testifying. And any effort that a mediator has to do to defend against a subpoena or other order to testify, typically mediators, including myself, in our agreements require the parties to pay for our fees in defending against
I've seen your agreement, and you say, let me make it very clear, I can't be called as a witness, I'm protected by law, and if you try to make me come to court as a witness, I will defend myself and I will oppose that, and I will ask the court to award me any expenses I incurred in opposing your subpoena.
Exactly. Along those, or related to this topic is, what happens at the end of the mediation?
Right.
If you do settle? Well, because you can't have me come and testify, and because everything else is confidential, you can't present it to the court. If you don't get it in writing, at the end of the mediation, you haven't got an agreement.
Yeah, it's virtually impossible, if not actually impossible, to uphold an oral agreement made in mediation.
It is. I will say, however, though, and my philosophy about this has changed over the last year or so, but because of that, there is a tremendous amount of pressure that I see other mediators pushing to get that in writing before the parties leave. And as a practical matter, if you don't get it in writing, you don't have an agreement. But being in that situation as a lawyer in the mediation process and feeling pressured when the client's tired, obviously, and maybe not having given it all of the best thought that he wanted to. I've come to the conclusion there's nothing wrong with saying, this is great, it's good today, if it's good today, it's going to be good tomorrow, let's go home and sleep on it, and then we'll write it up.
Amen. I agree, because it's essential that you have it in writing, or it's not binding.
Correct.
But the problem is, it's an all-day mediation, and we only fully realize that at 4:30. And that's when we make our deal. And then we've got 30 minutes to write up a 20-page agreement.
Especially in divorce cases.
With
because
kids and
yeah.
And what happens is, just as Dan mentioned, we're scrambling to get everything done. And so not only are we tired, but there's just not enough time. And so we can get careless, and we can fail to include ideas. We can be working off of a draft of something we started with where we forget to change things. And so we can end up cobbling something together at 4:58 as if we're trying to beat some deadline, like before the bomb goes off.
Yeah.
We sign everything, and then we find out that's not what we wanted. Both parties.
Exactly.
Not just one. Sometimes it can end up where one person gets favored over the other, and that's bad enough. But other times it's like, now, if both parties didn't like it, they may go back and change it. But how many times have we seen where one party takes advantage of the other's tiredness or inattention and said, "Oh, hey, you signed it. I didn't hold a gun to your head," and you're stuck with it.
Yeah.
The mediator can't tell the court what really was agreed to. The mediator may not even remember. So you're
Correct.
stuck with this agreement. It's like, look, you both signed it. Your lawyers were both there. In fact, your lawyer wrote it.
Exactly.
I
So,
agree. Yeah, saying to come back the next day to draft it, what may is a good thing, or just one of the lawyers will do it and they'll pass it back and forth. Sleeping on it, yeah, you may run the risk that it's not going to get done. But I mean, if you agree at 2:00 and you spend 3 hours working on it, you're probably fine.
Right.
But if you're going to go home in 20 minutes or an hour, just shake on it and say, let's exchange drafts, or let's come back for a second round of mediation, simply to put it in writing.
Exactly. That's where I am in my practice now. I am not going to. Yes, it's nice to have another case that you successfully mediated to a settlement, but more important is that the parties have an agreement that works for both of them. And and sometimes these mediations go till midnight,
Yeah.
and they're very tired.
Yeah, I could say the longest I was in a mediation till 2 a.m. And I'll never do that again. That's all it took.
Did you settle?
We did settle, but some mistakes were made. Fortunately, the parties were good enough to acknowledge that we had been up till 2 a.m.
Right.
and we made some mistakes. Unfortunately, there were mistakes on both ends, so it's not like anyone could take advantage. But I'll never put myself in a position to. I mean, I was foolish to think that we weren't going to make mistakes, staying up till 2 a.m.
Yeah. Another thing I like to do is have the parties put down in maybe bullet form the essential elements of their agreement, and then at the bottom of the agreement, I even have a form for them to do this, that says, they check a box that says, this is all subject to our further agreement to a formal document.
I really like
put-
that. I don't
put
think
into
I've
the form
ever,
later.
when I've used you as a mediator, I don't think we've ever been in that situation, so I've never seen that form. But I love the concept, because it helps to keep people honest if they were inclined not to be, but doesn't lock anybody down. We know what the direction we were going was,
Exactly.
but we also weren't rushed.
It memorializes what the progress you made, acknowledging that you've got some further progress to make before you can actually sign on the bottom. But allows you the freedom to think about it too before you sign.
Okay, well, before I have you give your contact information again at the end, we've signed our agreement. What does the mediator do next? Or the parties, for that matter?
The mediator furnishes the ADR disposition notice.
To whom?
He furnishes that to the lawyers, if there are lawyers. If there aren't lawyers, he can send it directly to the court. He or she can send it directly to the court. Or he can give it to the parties, and the parties then can file it with the court.
And then your involvement is over.
That is correct. And my practice is to destroy my notes, and I just preserve a copy of the mediation agreement, so that if I ever have to enforce that in the future, I can.
Okay. Thank you so much. That was a great overview. And
You're
not just an
welcome. Thank
overview,
you.
but an explanation. I think people are far better informed now. as a result of this conversation as to what mediation in Utah in a domestic relations case involves. So, again, so the people who may have forgotten from the beginning, can you run through your name and contact information again?
Sure. Daniel L. Day. My address is 9571 South, 7th East, Suite 104, Sandy, Utah, 84070. And my phone number is 801-676-1506.
Thanks again.
Thank you.